In Massachusetts, when DCF removes your child or your children, one of the questions that many people have is part of the care and protection or the 72-hour hearing or temporary custody hearing, whether to waive your right to that hearing or not. There are pros and cons, and it always depends on the situation. You do need to think it through because it can be a long time before you'll have a trial and have another opportunity to have a hearing. Many times the DCF might have overwhelming evidence or there might be good reasons to waive that right to a 72-hour hearing, but you want to think it through. You are entitled generally to a court-appointed attorney if you can't afford to hire a private attorney. So regardless, you should speak to an attorney about it one way or the other. There is a piece of paper that the court goes over with you and the attorney goes over with you explaining these rights that you'd be giving up by waiving your right to a 72-hour hearing. And you need to go in front of a judge, and the judge needs to make sure that you understand everything and that you're knowingly and voluntarily choosing to waive the hearing. If you choose to waive a hearing, it means you're giving up your right to have that hearing and gives up your right to testify or to present evidence on your own behalf, to cross-examine the social worker or other witnesses for the department. And it may or may not be one that you're waiving your right to a 72-hour hearing for yourself, but you're seeking to have a 72-hour hearing, or you're supporting the other parent, or that you're asking for a third-party custody hearing for the other parent. It's very important, though, to make sure that you understand the right that you're giving up by waiving that right to a 72-hour hearing, or what you need to do in order to be prepared for that 72-hour hearing or temporary custody hearing. And it's important to discuss that with your attorney prior to the day of the temporary custody hearing, if at all possible.